What's your best support for what appears to be your argument that a pretextual regulation is per se unconstitutional?
I would start historically with Blackstone and the meaning of the word infringed in the text of the Second Amendment. If you look to Blackstone, which is one of the main sources underpinning what the pre-existing Second Amendment right meant, the canonical example of a law that burdened impermissibly the right to bear arms was the English game laws, which under the pretext of trying to preserve game were designed to prevent commoners from hunting. And we know that was one of the animating premises of the Second Amendment from people like St. George Tucker, from Justice Story. And again, the very meaning of the word infringed in the Second Amendment shows this is part of the history and tradition underlying
firearms. Analysis that you're suggesting, Ms. Harris, is this part of the Bruin test, or is it something separate from the Bruin test?
It is part and parcel of the Bruin test. It goes to why the law is regulating the way it does, in Bruin's words. Or in the word of Rahimi, it goes to whether there's a permissible reason. It helps you tell whether the analog is really an
you're
analog.
on step 2 of the Bruin test. You think about pretext. Is that what you're saying?
I think that's fair, because step 1 is, are you regulating arms-bearing conduct? And so one of the parts of whether you tell, is this part of the history and tradition, and are the potential analogs really analogs, as you say, why is this modern law regulating the way it is? And if it's pretextual, by definition, you're not going to have analogs, because there is not a history and tradition of pretextual laws that negate the right.
Why do we need to make it? Oh, go ahead.
Mostly in our constitutional law. I mean, there are exceptions here and there, but mostly in our constitutional law, we've steered clear from trying to evaluate motive, purpose directly. You know, we create rules that maybe are meant to ferret out bad motive, but we kind of think it's a bad road to go down if we're going to ask about every state's, whether the state is acting pretextually in doing one thing or another. And I'm just wondering why we would have a different thought with respect to this right.
Because respectfully, that's not our position. We're not saying, think about what's on people's minds. If you have bad motives, it's a bad law. What we're saying is, look at the text and see if there is a fundamental mismatch. If the law is gerrymandered textually, which is the case here, in such a way that belies the assertive motive.
So
that is familiar.
That seems fair, but then it seems as though that's classic means-end scrutiny. You know, look at over-inclusion, look at under-inclusion. Is the state really regulating what its interests would suggest ought to be regulated? So that's means-end scrutiny, which I thought Bruin was supposed to get us away from.
So 2 points on this. Respectfully, no, we don't think so. We think Justice Churchill-Lukumi in the First Amendment context is a case about pretext and not sort of means-ends. It's about how do you tell from the text of the law, is it gerrymandered in an impermissible way? That's what we're asking for here. And the Second Amendment, of all places, in terms of history and tradition, is where this test would apply. Because again, the original meaning of the word infringed in 1791, and I would point you to the Daniel Slate article on this, infringe, what included the Blackstonian concept that if you are regulating for a pretextual purpose that is belied by the design of the law, that is a classic means of infringement.
Why